Number 23-778. Court has reviewed the second amended motion as well as the state's response. Mr. Niddle?
Yes, sir.
The floor is yours, sir.
What's that?
I said you may proceed.
All right, thank you, Judge. First of all, I think I need you to help me flip a switch or something up there so I can get these two videos on your screen.
Okay. You want to put them up on the wall, right?
Yeah, this is not my laptop, so I'm not sure how to get this thing started.
Which, is it connected? Are you,
Yeah, it's connected. Choose
you
here.
plugged into what? Plugged into 2A?
It looks like 2 A's.
Okay.
There we go.
Is that yours?
This, yeah, well, this is court IT's. Figure out how to get off the screen here. She didn't tell me the password. Did you ask her for the passwords?
She wrote it on the sticky note.
Oh.
Yep.
Your Honor, am I still reading?
I don't believe so. Thank you very much. Appreciate it. Sorry for not paying attention over there. You're so quiet. See. It's case sensitive, Mr. Niddle. It's case sensitive, just FYI.
No, it's going to be the whole, it's that entire thing.
There we go.
And before you turn that on, are you gonna,
I will, I just want to get it started, get it prepped and then start.
okay, very good.
The said general affidavit of the application for the search warrant, and hereby deemed sufficient to show probable cause for the issuance of this search warrant, which was signed by the honorable. Okay, so we're there in the front room, and
I would call Officer Mike Evans to stand judge.
Very good. Madam Clerk, would you swear the witness?
Do you swear that your testimony about to be the truth, the whole truth, and nothing but the truth?
I do, ma'am.
Thank you.
Please be seated and talk right into that mic. It's very directional. You got to talk right into it.
Yes, sir.
Mr. Niddle?
Thank you, Judge. Thank you, Mr. Evans. Mr. Evans, we're here on the case involving Mr. Johnson, and I believe you were the lead officer on that case. Is that correct?
Yes, sir. I was the lead investigator.
Okay. And I've got it queued up for a search warrant that was executed on February the 9th of 2023, I believe. This search warrant, the affidavit for that search warrant indicates that there were downloads at this residence on 715 Glen Place from June, I believe it was the 19th to the 29th of 2022, is that correct?
I don't recall the exact number dates, but if you had the search warrant in front of you, I could verify that, but
Yeah, I can show you the search warrant. How many approaches this?
You may.
I believe it's on page
that's all right, I can find it real quick.
it's on page 5.
June 19th, 2022 through June 29th, 2022, sir.
Were there any other dates that you were aware of child pornography being downloaded on at that residence?
For the IP for that residence, no.
Okay. I noticed that in one of your reports, I believe it says that there was, I don't know if this was, when you received it, or when that, I believe there was one from January.
Excuse me, Mr. Newman, may I ask what you're looking at? Investigative evidence? No, page 2.
I'm just referencing this paragraph, just to clarify. Let me show you a report that you produced.
Sure.
It indicates from January 18th to January 19th. Is that something that, was that a different download, or was that something that was related to the initial download?
I apologize. This was a download that occurred on another case because would you like me to explain like the peer-to-peer before I move forward, or?
That's fine, yeah.
Okay, I just making sure, sir. So we don't, obviously when we run this program, we get only an IP address. We don't get like an address or anything like that. So this IP address came in where we received a single source download on from January 19th to January 18th to the 19th, I apologize, where this IP address had come back. And then
Same IP address as the garden?
I would have to go back and look at the other case. I don't remember off the top of my head because the IP addresses can change. The company can change those. And so when the subpoena was sent for this IP address for those date and times, it came back to the 715 Glen Place. So I had closed out this investigation because it came back to the same place where I already had a previous investigation for the OCSO 22 OFF 010766, sir.
Okay, so if I understand you correctly, then was there two separate dates or two separate time periods when child porn was being downloaded?
Yes, sir.
And that was at the Gardner residence?
The 715 Glen Place, yes, sir.
Okay. You didn't put that in your search warrant, that's why I'm wondering that those dates are not in your search warrant.
No, they weren't. I went off the original stuff, and I honestly could have just forgotten about it when we were doing it because there was a lot going on during that time frame.
Okay. Anyhow, the original search warrant was June the 19th to June the 29th of 2022.
Correct.
And then this indicates from January 18th to 19th of 2023, which would have been about 2.5 weeks before you executed the search warrant. Is that
Correct.
Okay. And you drafted the search warrant on February 8th, I believe, is that correct, the day before you executed it?
Oh, no, I didn't, I drafted it a while ago. It was probably signed
Okay,
before that.
I apologize, it was signed just a few days prior to that.
Correct.
Okay. And when you arrived there, you spoke, Mr. Gardner is the person that lives there, is that correct?
I spoke to him and other people, yes, sir.
And Mr. Gardner had, I believe there was there was 2 other women and 2 other males besides Mr. Gardner at that residence.
If memory serves me correct, yes, sir.
Okay. And during well, let me just play this video real quickly.
Your Honor, I'm going to object at this point to the video being played. I don't believe we have any authentication of it at this point. I'm not even familiar if the witnesses have an opportunity to view it and can authenticate it.
I'll put it up, and he can identify it as whether or not it's his.
We still don't know if it's true and accurate representation of what was done that day until the witness has an opportunity to review it. I think that's required.
Well, I mean, until he views it, how can he tell?
Because normally it needs to be authenticated before it's shown to the prior effect. The court wishes to proceed, certainly the court can. We have no way of knowing if there's been any changes to it, is all I'm saying at this point.
But should he do it before? I mean, this is not a cooperative witness
Well,
by the defense. How would they determine whether or not it's?
Your Honor, generally, the procedure is if a party is going to call a witness and ask that witness to authenticate evidence while they're on the stand, they would need to review the evidence prior to taking the stand so that they can say, yes, this is a true and accurate representation or copy or the appropriate words given the evidence.
How long is?
I only want to play the first 4 or 5 minutes, Judge. There's 2 videos. One is the search warrant, which he executed on February 9th, which is up there right now. I want to play the first, I believe, 4 to 5 minutes of that. And then after they executed the search warrant, they detained Mr. Johnson just a short ways away from the premises. He was riding his bicycle, they pulled out, and they saw Mr. Johnson and they detained him. That's his body camera as well.
I certainly would agree with you if we were talking about a jury. I mean, a jury, we couldn't show it and then authenticate it, but I think I can differentiate. If there's something that's in there, you can ask him whatever questions and as far as authentication prior to Mr. Niddle asking any questions, if you have some questions yourself about whether it's authenticated.
Understood. We just want to make sure that the record was clean.
Okay.
Yes, sir. And then once I have my room, now some of them were out in the dining area at one point.
Okay.
But I wouldn't.
Did anybody have access to those?
Not that I know of. Maybe Paul.
Okay. You think Polly had access to those?
Some of the ones.
The said general affidavit of the application for the search warrant, and hereby deemed sufficient to show probable cause for the issuance of this search warrant, which was signed by the Honorable Judge Stone. Okay?
I feel some kind of way about that.
Okay. So I'm going to talk to each one of you. Once you guys get your cuffs all done, Investigator Gerard and Investigator Keel will have you sit over there. Mark, I would like to talk to you first, if that's okay. We're going to go stand over here and talk. Okay, I told you.
Yes.
Okay. So,
I thought it might be something, other than that, but,
I didn't have something else I got to worry about.
That's right.
Because I worry about fentanyl. Obviously, it's killing people.
Yes, my mother was a nurse, so I know better.
Yeah, all right, so.
Mr. Niddle, you might want to turn that up a little bit.
Do you have any computers?
Yeah.
Okay.
Where they at? They're in that front room.
Front room?
I have some of mine, they're behind, there's no way.
Okay.
That I know of.
Okay, so computers
They're under my bed,
in front?
in the front room. And then there's all kinds of computers stacked up, and they're just gone.
Okay. Well, are they stacked up outside?
Yes.
I don't wanna worry about the ones outside, I worry about the ones in the house.
And the ones that are in the house are mandatory ones. So
Okay.
And what I was trying to do was trying to make canvases.
Okay, so we're there in the front room and in your room under the bed?
Yes, sir. And the ones I have in my room, now some of them were out in the dining area at one point.
Okay.
But I wouldn't.
Did anybody have access to those?
That's what I know. Maybe Polly.
Okay, you think Polly had access to those?
Some of the ones.
So
But now-
you've heard the story before,
I
what's
have
the,
heard
what's
that.
the story?
From Polly. I heard that he was at somebody's house and the same thing happened to somebody else. What I heard.
You know, it's funny, I've heard the same thing.
And Rick too.
So,
And now-
that Rick over there?
But the thing, I asked Rick, I said, no, nothing, porn. Thing, he said, no. He said, I've already been trouble with that one before. I said, okay.
Oh, Rick's been in trouble for that
I
before?
didn't really say anything about that.
Okay.
But he didn't say about it because that's what he was doing.
They were using so your internet's Cox.
Yeah.
It's in your name.
Yes, sir.
Okay, that's how I got here.
Okay, so yeah, that's making me look bad.
Mm-hmm. And I told you, what did I do about that? And I told you. So
I
here's
raised my daughter. I was like a man in Okaloosa County to get custody of the little girl.
well, and I told you I didn't necessarily believe it was you.
No.
So, but obviously I don't know you, but you know what I'm saying. So, so obviously I'm gonna have to take those computers and clear them.
Yes, sir.
Okay.
They're porn.
I don't give a crap about that.
I'm like, ready porn all the time, but I'm not child.
I don't care about that. So, okay, here's my question. That's why I need to find Polly.
Now, I do not know where this came because I wish I did, but I'm not pissed off. I'll take it there.
Okay. So,
Just so you want.
when we get done today,
Yeah.
well, and I don't, Tim's not here.
Yeah, I know.
So, and I need to find him. Because I've been trying to have Polly for 3 years.
As mad as he's got me right now.
So,
Is this what the deal is? Because, I'll set him up.
so I've been trying to hunt him for 3
I'll
years.
see if I can't get him over there.
So,
If you all wait for him, and see what's happening, we'll show up.
or just call me and tell me where his camp is.
I'll send him, I'll find out.
But, and I'll be looking this afternoon, but I'll leave you with my cell number.
Yes.
Well, I figured you would be.
With his ass.
So, okay, I've sat down and watched this stuff. Hey, JK, Marcus told me there is computers in the front room and under his bed. And that's where his computers are.
The ones that are under the bed are either my dad's, my daughter's, mine, and a few of them recent, and I did find a few now. There are two of them that I found, which is a T-Shiba and
Where'd you find those?
a garbage.
In the garbage, okay. But you don't know if Polly is
garbage, it was just junk.
In your bedroom or your bed?
Yes.
Someone asked you, is there due from it?
Huh?
Do you have a code on your phone?
Yes, it is, my birthday, 8/10/7.
8/10/7.
8/10/7.
Okay.
7:00.
8/10/7.
Hey, 810-70.
No, 8/10/7.
810-7, sorry. Apologize, Mark.
Yeah, my bad,
No, you're good, you're good.
said my birthday was 7.
All right. So,
Yeah, I'm not putting it on.
well, I didn't think you would, and that's my whole thing. That's what I'm trying to find out.
I'm sick to my stomach. I operated on the floor.
I understand.
And, yeah, I went to the rock to do that.
So, I've watched, I know a lot about you guys because I've watched obviously we have body worn cameras. I've gone back and watched the body worn cameras. So January 25th, I know it's about 2 weeks ago, was Polly here on the 25th, staying overnight
I
there?
believe so.
Okay. And he has access to your Wi-Fi?
Well, he's been hanging out with Crystal. He's surprised.
Officer Evans, you just asked Mr. Gardner if Polly was there on January 25th, is that correct?
Mm-hmm. Yes, sir. Sorry.
That's not within either of the time frames that we discussed when child porn was being downloaded,
Yes, sir.
is that correct?
Yes, sir.
So Mr. Gardner did not provide you with any evidence that Mr. Johnson was there during the time frame that porn was being downloaded at that residence?
He did not give me an exact date, but through our conversations, he'd said Polly had been staying there for a while. I mean, the defendant had been staying there for a while. Sorry, I was just watching the video.
Okay, but I'm just saying, in your search warrant affidavit, both of them, you claim that you had evidence that Mr. Johnson was at these residences during the time frame when child porn was being downloaded.
Yes, sir.
Correct?
Yes, sir.
And the date I just heard was January 25th, which is not within either one of those time frames.
I answered yes, sir.
So what evidence were you referencing in your search warrant?
I was referencing the fact that he was still receiving mail there. I was told that he'd been staying there for a while. Also, the evidence that he was arrested in the October timeframe, and gave that recent address. And speaking to Mr. Garner and the other occupants there, they had given me rough timeframes that he was there and that he'd been staying there and coming back and forth to visit the other young lady there.
But we're talking about specific dates.
Sir, was what
Well,
I
that's
based it
my
on.
question. Do you have any evidence that he was there during those specific dates?
No hard evidence, no, sir.
So nobody said that, yes, Mr. Johnson was here between June the 19th and June the 29th?
Correct.
And nobody said Mr. Johnson was here on January 19th or was it 18th and 19th?
Yes, sir. And that's yes to both answers, sir.
Okay. So did you have when you wrote in your search warrant affidavit that you had evidence that he was present at the location where during the time child porn was being downloaded, what is that based on?
I've already answered that question, sir.
Well, I'm asking, what is it? It's not based on anybody. You just said that nobody told you that Mr. Johnson was there during those time frames.
That's not what he said.
What's that?
That's not what he said. That's not what he just said.
I asked him specifically if anybody told him that Mr. Johnson was at that residence between June the 19th and June the 29th, or...
What is the evidence that you have that the defendant was at the residence on either of these timeframes between June 19th and 20th of 22 or January 18th and 19th of 22?
Statements that individuals said that he was staying there on and off, that he actually had residence there, that he stayed in the living room there, he had access to the electronic devices.
And where did that come from?
From the witnesses that lived at the residence.
Okay. That's what I heard him say before.
Okay. But the question is, these are specific dates that he's alleging.
He just answered the question regarding specific dates. You can ask him again. I'll allow you to try and clarify it, but he answered the question.
Yeah, that's what I'm trying to clarify, is why is it say in the search warrant affidavit that he had evidence that Mr. Johnson was at these places during the time period where these things...
I just asked the witness that, and he just answered it. You may not like the answer, but that was his answer. You may not feel like it's adequate, but that's his answer.
Okay.
Excuse me.
Sir, I'm not trying to be an asshole. I'm homeless. I'm on the street.
Yes, I know, Paulie, and I've been hunting you for a long time.
The date of this video is the same date as the search warrant. It's about 8 minutes after you ended your search warrant at 715 Glen Place.
Is that a question, or is that a statement?
I'm just making a
Mr.
statement, Judge.
Pardon?
If I may, I'm just making a statement, and I was going to follow that up with a question if you allow me.
I will, but you didn't sound like you were asking a question.
Well, I'll get to the question. I'm just
Okay.
letting the preface. This video is was shot about 10 minutes after you left the 715 Gardner Place where you executed the search warrant. And did you just happen upon Mr. Johnson at that point?
Actually, yes.
Okay. And he was riding his bicycle, is that correct?
Yes, sir.
Okay. Did you turn on your lights or siren to get him to stop, or how did you get him to stop?
We don't have lights or sirens in that particular vehicle we were in. It was our little forensic van. And I hopped out and hollered for him.
Okay. And so this is just very shortly after the search warrant, is that correct?
Yes, sir.
Why?
No, I don't.
Polly, I'm gonna find out where your stuff is. So just tell me where your stuff is.
I ain't got no stuff, sir. You have no right to detain me any further.
You're a suspect in my investigation, so I'm stopping you right now, okay?
And what investigation about what?
Okay? In reference to possession of child pornography.
No, I've been cleared of all that, sir.
No, you haven't. Because I was the one investigating you before, and I found out you were at another house where it was being downloaded.
There's several houses that's been downloaded. That doesn't mean I was involved in any of them.
And you were there at this last one.
I was there at all of them. Doesn't mean it was me. I'm not the only person that's got access to them things.
All right, well, hold on one second. Do you have a rights card? All right, before I ask you any questions, I have to advise you of them. And that's the law. Okay, you have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to the lawyer advice before you ask any questions and have him with you for questions. If you can't afford a lawyer, one will be going for you before any questions if you wish. If you decide to answer questions now without a lawyer present, you still have the right to stop answering any time. You also have the right to stop answering
I don't have anything like that, sir.
Okay, do you have any electronics on?
No.
Do you have a back? You had a whole bunch of them back at Joe's camp.
I know that, and I quit messing with all that stuff, man.
Headphones going in your pocket. Where are those headphones go? Where are they connected to?
Nothing.
Nothing?
What about right here?
Nothing.
Do you mind if I look in your bag?
Yes, I do, money.
Well, guess what? I'm going to seize that bag.
You can't see
I
that.
can because I've already done all this, Polly.
You haven't.
I've already talked to the state attorney's office.
I don't have anything, man.
Okay, I know it's you.
It's
So
not
stop
me.
playing this game with me. I'm tired of it. I'm tired of letting you. You've been downloading for the last 3 years, man. I
No,
know you
man.
have been.
Dude, you're wrong, man.
Okay, then, where are you camping at? Prove me wrong.
My camp's over down the road over here by fucking Herbert Field Road.
Okay,
All
alright. So if I got someone to take you over there, would you show us your camp?
right? Yeah, I'll show you my camp.
Alright, and you're gonna show me your bag?
Yeah, I'll show you my bag when I get to my camp.
Okay.
All right.
Alright, well, Casey, call dispatch and see if...
You follow me.
No,
I'm not
no,
going
no.
anywhere.
I'm gonna give you a ride over there. I'm gonna give
No,
you...
I'm not.
No.
No, sir, you're not.
I'm not following you on a bike because I could lose you.
No, you can't, man. I'm not. I'm sick, dude.
Polly.
Listen, man.
I'm
I'm not.
Polly?
Listen to me, man. I'm not.
Polly, if you try to leave, I will put you in cuffs for resisting. And that charge will stick.
I understand that, man. I'm not doing anything wrong, dude. I haven't done anything
Okay,
wrong.
I told you, we would go with you over there.
I don't get it, man. I haven't done anything wrong.
You're a suspect in my investigation.
I understand that, but that don't give you a right to sit here and treat me like this. I haven't done. I'm
I'm
cooperating.
detaining you. I have a right to detain you.
I've cooperated with everything. I don't have nothing, sir.
Okay? Then if you don't, that's fine. Then you don't mind us, if you're sick, giving you a ride over to the
Just follow me on the bike, man. I don't want to get in the car. I don't have to.
Well, how about I walk with you?
How about that? Fine. You want to walk with me? I don't walk very well.
All right, we'll walk together.
But I'll push my bike.
Okay, come on, we'll walk.
Okay, at this point in the conversation, you told Mr. Johnson that that if he tries to leave, that you're going to arrest him for resisting arrest. Is that correct?
Yes, sir.
And you've told him that you're detaining him.
Is that yes, sir.
Okay. Now, in order to detain somebody, you have to have a reasonable suspicion that they've committed a crime based on articulable facts. Can you tell me which facts can you articulate to give you grounds to detain Mr. Johnson at this point?
Yes, sir. Mr. Johnson's name had come up in 3 different investigations where we had executed search warrants to houses, and not just the Okaloosa County Sheriff's Office, but FDLE, that he had access to that house and access to the internet to that house. All of those people had said that he was like one of the only people not there when we executed the search warrant. We found no child sexual abuse material on any of the devices that were there. Also, we were also looking for an individual at that time that we believed also was downloading from public Wi-Fi's. And those public Wi-Fi's were also in the area of Mr. Johnson's camp within a 5-mile radius. Actually, one was 500 or 600 feet away. So in previous other investigations, his name has come up a number of times as to the one downloading the CSAM material, and that is why he was a very strong person of interest for me in this case, especially when we had already been at 715 Glen and had cleared all the active devices there, and nobody had any type of child sexual abuse material or any type of peer-to-peer programs on their phones.
Okay. So if I understand you correctly, there had been, I think from our deputy, there was 2 prior search warrants prior to the 715 Glen?
There was 3 total, including FDLEs.
And did anybody at those properties, they told you that Mr. Johnson had been there?
Well, originally, I was only given the name of Paulie, and we had to research and find out who Mr. Johnson was and try to identify him, because he only went by Paulie to a number of those people.
But their information was that he had been there, but he was no longer there.
Correct.
Did anybody at any of those prior locations tell you that they had seen him on the internet?
I don't recall.
Did anybody tell you they'd seen him downloading anything off the internet?
I don't recall at this time.
Okay. And I think we talked about the deposition when he was camped behind Walmart. You also confronted him during that incident. Is that correct?
That was within, I don't remember our deposition that well, I apologize, but I believe he was camping to see either Walmart or Sam's Club, because one of the targets that had an open Wi-Fi was, at the time, I don't think they're open anymore, was Rockstar Kickboxing. And it was literally just down the road from there on an area that was undeveloped.
Okay. So now at the time you're telling Mr. Johnson that he's being detained, you had information that he had been at 2 prior residences where child porn was being downloaded, apparently during the same time period when it was being downloaded. Is that correct?
Yes, sir.
And at 715 Glen Place, I believe Mr. Gardner said, I believe he was here. Was his response to your question about Paulie being there?
So Mr. Garner, his place of residence was essentially a junkyard, and he let people crash there on and off. He had let Mr. Johnson stay there for an extended period of time. During that time frame, Mr. Garner had gotten a girlfriend, and she and Mr. Johnson did not get along. So I don't know if Mr. Gardner asked Mr. Johnson to leave or Mr. Johnson left on his own, but because of tensions there, Mr. Johnson was not staying there anymore. But he would come back to collect his mail. His mail was still being delivered there, and he would come back to see one of the other females that was there that he was friends with.
Now, Mr. Gardner told you that Paulie may have had access to the computer, but he didn't say that he saw Paulie on the computer. Is that correct?
If that was what was in the video, yes, sir.
He also told you about an individual named Ricky that was at that residence. Is that correct?
Mm-hmm.
And he told you that Ricky had told him that he had had problems with a child porn incident prior to that. Is that correct?
Yes, but I believe Ricky was still at the residence.
Yeah, Ricky was there.
And I spoke to Ricky about that, and Ricky said no, and we ran Ricky's criminal history. And
Oh, you did run his, that was going to be my question.
yes, and he did not. And we actually went through Ricky's property and stuff, and he had nothing as well.
So Mr. Gardner was mistaken when he told you that? then?
Correct.
So, okay, so you did run Ricky's information, and he didn't come back with it?
Yes, sir.
Okay. So at the time we see you with Mr. Johnson here, at that point, you had information that he had been at a total of 3 residences where child porn was being downloaded. Is there anything, those are the facts you had?
Technically, it's 4 residences.
Well,
If we're counting 715 Glen. We have 2 of mine, 1 of FDLE's, 715 Glen. Then we also have the vicinity of where he was and all the totality of all the other interviews that were conducted in all the other places. So yes, that gave me reasonable suspicion to believe that he was a strong person of interest for my investigation.
I understand that you had a suspicion, but my question is, the facts that it's based on was the fact that he was just present at a time and place where child porn was downloaded.
And the fact that if you heard Mr. Garner say, I've heard this story before, meaning other people have talked about it, meaning other people are talking about the fact that, hey, Mr. Johnson was at my house, they came and hit my house for possession of child sexual abuse material, and none of us did it, but he's the only one that's not here.
Rumors are facts?
No, but you follow, because same as the narcotics, you hear so-and-so is dealing, you start gathering other information. When you have an overwhelming amount of search warrants where they end up with nobody in there, but the same name keeps popping up, then that campsite's within a 5-mile radius of a bicycle easily gotten to. One of those places was, like I said, Rockstar Kickboxing. Another one was the Walmart. Another one was the Starbucks. The other one was a homeless shelter that was used. All within vicinities of where that campground was. So yes.
Okay. But I'm saying that's it. This is proximity. There was no information from anybody saying that they saw Mr. Johnson downloading anything off the computer.
Nobody personally viewed him viewing child sexual abuse material, sir, if that's what you're asking me to say.
Nobody saw him on the computer either. Is that correct? Or nobody informed you that they saw him on the computer?
That would be correct.
Okay. No. After you spoke with Mr. Johnson, you told him that if he tried to leave, you were going to arrest him. He agreed to walk with you to his camp, is that correct?
Yes, sir.
And it was about a 12 or 14-minute walk.
Sure.
It looks like this is the,
Yo, incoming, got company, straighten up. Kevin, need your help. Need your help. There's my thing right down the left of the road, right there. Nope.
All right,
Sorry,
here you go, here,
I got the bike.
All right, I didn't want it to fall over on you.
It's not going to.
Polly over here with us.
I'm giving him his bag.
It's your bag right now, it's not going anywhere.
No, Polly,
Polly.
Polly, no.
Take it.
It was in his possession, sorry, sir.
No, it's
You
his
do not want
bag.
to take that bag.
You don't want to take that back.
It's his bag, man.
Polly?
Listen, you don't have a warrant to
It's
search
his
it
bag.
anyway.
Polly, I have a right to seize it.
Can
We
we
have
have your bag, sir, if that's your bag?
Is that your bag? Come over here. Come over here, talk.
You want to talk to me, my problem.
You don't have a right to see
I'm investigating him for possession of marijuana right now.
it. No,
Yeah,
you don't have
and I have good reason to believe that he has it in one of his electronic devices. I would not lie to you. I walked 2 miles to find it. So is that your bag?
No,
Because if you claim it, I find CP in it, guess who gets in trouble? I don't want to put anybody else in trouble.
No, I'm not. You can't take the bag. You can't search the bag without a warrant. You gotta have a warrant before you can take the bag, search the bag, in your bag.
All right.
No, it's
See,
not.
I can seize it. I don't have to search it. I can seize the whole bag.
No, you can't.
Polly.
You gotta have a warrant to do that.
Polly,
Go look in my tent.
I'm going to snatch that bag from you in 10 seconds. He just said it was not. Polly, quit. Let go. You're going to catch a charge. He's not hit Polly. You're going to catch a charge for resisting. Let go. You got 5 seconds. 4.
All right.
He just said it wasn't his bag.
Doesn't matter. You can't touch
I
it.
can seize it.
You can't
When
see
you lay
it.
down, you can sit down, or you're going in handcuffs, and then you're going to sit down. So it's your,
so it was at this point that you seized his bag, is that correct?
Yes, sir.
Now, you had originally told him, like, I think it's at 1:38 on this tape, that I'm gonna seize that bag. You said that at 1:44. Why didn't you seize it at that point?
I wanted to give him the opportunity to talk because, first off, we started off kind of contentious, and then when we were walking back, we actually were talking, and he had also said that when we got back to the camp, that he would allow me to look in the bag and into his tent. So, say he's cooperating. Say he has nothing in the bag and he cooperates just fine. Nobody gets hurt, everybody's comfortable, we move on. So instead of trying to snatch a bag off someone's back, right then and there, possible cause injury, give somebody the opportunity to comply and work with law enforcement.
Okay. But at the point he told you that, he was detained.
That is correct.
Okay. Now, you seized the bag. A few days later, you got a search warrant for that. See if I can find that search warrant. If I may approach, Judge.
You may.
This is the search warrant you used to look to open the bag and search the bag, is that correct?
sir.
And this search warrant was applied for on the 20th of February, approximately 11 days after the seizure.
Yeah, that's when it was, I was sworn to it. It might have been, when did the judge sign it? Did he sign it that same day?
I don't,
Because it goes through a portal and it might take a day or two sometimes.
it was issued on the 22nd.
Okay.
I'm saying you submitted it on the 20th.
Yes, that would be correct.
In this search warrant, you're indicating that Johnson was living at the residence and had access to the internet during the time frame of the downloads in this search warrant affidavit as well.
Sir, I assumed that was the affidavit you were talking about earlier because that is the only time I ever referred to that. So I've answered that question earlier in this
No, your other search warrant indicates dates that child porn is being downloaded. It doesn't say anything about Mr. Johnson being there. Your other search warrant just says porn was being downloaded during
As I
these two time
explained
frames.
to you earlier, when we're using the program, all we're giving is an IP address. Once the IP address returns to the residence, we have to do lengthy surveillance and try to identify people associated to said residence, not just also living there, because someone could be associated at that residence that could have a lengthy criminal history or could possibly have firearms, and we don't want anybody getting hurt.
Basically, what I'm asking you is, both of these search warrants indicate that the first search warrant gives the dates when child porn was being downloaded.
The first search warrant is talking about the dates when the program was able to see that child porn was being downloaded.
Right.
And that does not mean it was not downloaded before or after those dates.
I understand that, but that's what you had evidence, that child porn was being downloaded during those specific dates. You had
That's
evidence
correct.
of that. And then in your search warrant for the bag, you indicate that Mr. Johnson was there during that time period.
Sir, I've already answered that question.
Do you believe that you had probable cause to seize Mr. Johnson's bag?
Yes, sir, I do.
And what would that probable cause be if you could enunciate it?
Sure. So at first we start seeing the hanging earbuds from his neck. Start asking, he starts denying the fact that he doesn't have anything. Okay, he agrees to go back with us to the camp. As soon as we get to the camp, he tries to separate himself from the bag, which he originally said was his bag in there. So he tries to separate himself from the bag and give it to somebody else to thus move away from that. I know from my training experience that as soon as somebody else takes that bag, or as soon as that bag leaves my sight, that digital evidence could disappear very easily, tossed in a ravine, tossed somewhere like that. So based off the exigency and the fact that Mr. Johnson originally said that was his bag and we weren't going to search his bag, but then when we got to the camp, it's all of a sudden not his bag anymore, it's somebody else's bag, that tells me that's my probable cause to seize it.
Okay. You had told him earlier that you could seize it, but you didn't do so. Is that correct?
Yes, sir.
Did you think you had probable cause when you told him that?
Sir, I'm allowed to use whatever means necessary to get someone to talk to me,
I understand that.
which means I'm allowed to lie, too.
I understand that. I'm just asking you. Did you
Well, I chose to seize it when I chose to seize it. That should answer my question.
Okay. My question was, did you believe you had probable cause to seize it when you first told him that?
Sir, I didn't seize it. Thus, I don't believe I had probable cause at that particular moment in time. But as everything went forward, and my investigation moved forward, I had the probable
You're
cause.
saying based on the fact that he tried to get rid of it when he got to the camp and the other things you cited?
Yes, sir.
Okay. Thank you. I don't believe I have any further questions. Just say, make sure Mr. Johnson doesn't have anything he wants me to ask.
Ms. Basso? Hold on. Are you finished, Mr. Nettle?
Yes.
Ms. Basso, you may inquire.
Your Honor, before I begin inquiring, does the court wish a copy of the search warrant for the backpack?
I
that
would.
Mr. Nettle referred to. Mr. Nettle, I have an extra copy that hasn't been written on. Now I was going to provide that to the judge.
I have copies for the judge. I meant to give him.
Whoever wants to give me.
I just have the backpack here.
Okay, thank you.
I need the search warrant for both of these places.
Good afternoon, Investigator Evans.
Good afternoon, ma'am.
Sir, about how long have you been working in child crimes? I believe it's been quite a while, isn't it?
December will be 11 years.
And in the course of your duties, you have had an opportunity, I believe, to be involved in many investigations that involve the possession and downloading of child pornography. Isn't that correct?
Yes, ma'am.
So I'm going to direct you to what we've been talking about here, Mr. Gregory Johnson. You indicated that he became a person of interest based on the totality of the circumstances, and I believe you indicated there was at least 2 residential search warrants where programs indicated that IP addresses at those residences were involved in downloading child pornography. Is that correct?
Yes, ma'am. Actually, there was 2 with Okaloosa County Sheriff's Office, 1 with the Florida Department of Law Enforcement.
And I was going to ask you about that one separately, but that was the same type of thing. There was IP address identified at the residence where a search warrant was then executed with FDLE.
Yes, ma'am.
That's correct. And in each one of those cases, you indicated to us that while there was evidence of child pornography being actively downloaded at those residences at the time of the search, there was no child pornography or no CSAM found. Do I have that correct?
Yes, there was no CSAM found, and there was no digital forensic artifacts of the peer-to-peer program on anything. So that means it was nothing there.
And so I want to be clear about that. So you went through, you or the individuals involved in the search warrant, went through all the electronics belonging to the individuals that were residing at those residences at the time, and nothing was found of interest to your investigation. Is that correct?
Yes, ma'am.
But in each and every one of those circumstances, you indicated that Mr. Gregory Johnson, otherwise known as Paulie, had been either residing at or had access to all those residences during the time frames of the download. Is that correct?
Yes, ma'am.
Now, based on your training experience, would it be accurate to say that if someone leaves a residence that they would take the items that are of value to them, like for instance electronics, with them?
Yes, ma'am.
And if someone has a transient lifestyle, based on your transient training experience, isn't it correct that the transient individuals would take the electronics with them from one place to another?
Yes, ma'am. Even if they leave the place where they're camping, they're going to take the most valuable items and keep them on their person because they don't know who might come into the camp.
Now, Mr. Niddle asked you about whether or not any individuals had ever observed in your discussions with them Mr. Johnson on a computer, but isn't it correct that the child pornography in this case was found on a phone?
Yes, ma'am.
So would I be accurate in saying that Mr. Johnson was very likely using a phone to download or access the child pornography.
Yes, ma'am.
So then you served the search warrant on 715 Glen, and we basically had the same set of circumstances again that you've already talked about, where there was an active download on at least 2 occasions that were identified by the program. Do I have that correct?
That's correct.
And here again, when the premises were searched and individuals' devices that were living there or staying there were searched, there was no evidence of CSAM found.
That's correct.
But those individuals all indicated to you that Mr. Johnson had been residing or had access to the property during the times of the download.
That's correct.
Now, is it accurate to say that based on this information now, Mr. Johnson was a person of interest that you wish to further speak to?
Yes, ma'am.
And matter of fact, in your video, body-worn cam, you mentioned to Mr. Gardner that you were going to be looking for him that afternoon.
I wanted to. We were extremely tired, so we wanted to identify where he was. We've been up since about 2:30 in the morning, so we were hoping to identify where he was and go talk to him later that afternoon.
And then when you left there, you did see him on his bike.
Purely by accident.
Now, at that point, he was already a person of interest, and did you make a determination to go speak with him then?
Yes, ma'am.
And how did you handle that initial contact?
It was initially like a citizen contact, and I could tell that Mr. Johnson wasn't going to comply, so I took the opportunity at that time to advise him that he was being detained, and once someone is detained, they have to be advised their rights, which I did immediately, and then proceeded from there.
Okay. And when you advised him of his rights, did you have any reason to believe that he didn't understand those rights?
No, ma'am, I believe he understood everything I said.
And I believe we saw in the video he chose to continue to engage with you at that point.
Yes, ma'am.
Now, in observing Mr. Johnson at that time, when you were first speaking with him, what, if anything, in your observations did you find to be relevant to your investigation as to him or what was on this person?
When he was first denying that he didn't have a phone, if you remember where we watched the video, the FDLE agent pointed out, and I observed, that he had a brand new set of earphones that plug into a phone wrapped around his neck, and we asked where those went to, and he said, well, nowhere. He kind of just tried to push it away.
Now, based on, again, your experience as a law enforcement officer and your knowledge of Mr. Johnson, would you say that he was living a transient lifestyle at that time?
Yes, ma'am, and that's what we were told too, back on scene at 715 Glen. We were told he was living at a campsite, or back living at a campsite. He had moved away. And that was a specific question, do you know what campsite he is at?
So given his lifestyle, would it be accurate then to say you had a reason to believe his electronics would have been on him as well?
Yes, ma'am, I believe that that bag would have been essential to all of his personal belongings that he wanted to ensure that stayed close to him.
And based upon your investigation and the fact that he'd been at or near places where child pornography was being downloaded, would you say that there would have had to have been an electronic device involved in those downloads?
Yes, ma'am.
And is it common for individuals that download child pornography to then store it on those electronic devices?
Yes, and store it and keep it in a place that only they can get access to.
And would it be accurate to say that a transient individual would then also try to keep that on or near his person?
Yes, ma'am.
And did that in any way lead you to have any concerns about that backpack?
It did at that time, but as I said before, Mr. Johnson had agreed to go back and show us the backpack and show us his campsite. So I was trying to give him the benefit of the doubt that we could, cooperate and work together. I've had plenty of times when I've given guys the opportunity and they've, moved forward with that particular opportunity. So that's what I was trying to do.
And so was that part of the basis for the reason why you did not take the backpack initially, when you first initially detained him and read his Miranda rights?
Yes, ma'am.
And then when you accompanied him and you said that the the conversation basically kind of came down a notch and almost became amicable, or at least interactive, as you were walking back with Mr. Johnson?
It was, because even after Mr. Johnson tried to give the bag away and we had to have that heightened discussion about taking the bag, Mr. Johnson calmed down right away, and the conversation was amicable even after that.
Well, let me go back then to, at the time, can you articulate just once more time for me exactly why you seized the bag when you did? You said, you accompanied him to the homeless camp or to the encampment. He was agreeing to show you the tent. Why did you then decide to say it was time to take that bag?
He tried to separate himself from the bag, and after he said that was his bag at first, then he says it's another individual's bag, and was trying to convince that individual to take the bag. So at that point in time, you could see not just myself, but FDLE agents saying no, no, no. And that's when we decided to take the bag, because he was separating himself from the bag, saying it was that other gentleman's property.
And so did you have any concerns that the evidence that you suspected contained therein might actually be destroyed, harmed, or disposed of?
Yes, ma'am, because I had no reason to, at that point in time, that other individual, I had no reason to detain him because he wasn't part of my investigation. So if he takes that bag and then gets on his bike and rides off, I lose all that evidence.
But you still felt that Mr. Johnson at that time was still a person of interest?
Yes, ma'am.
And subsequent to that bag being searched or being seized, you did not search that bag at that time, is what you've told us?
Yes, ma'am.
And then you actually said you had the conversation with Mr. Johnson, kind of calmed down, and you were able to interact. Was he able to, or in the course of that conversation, he actually then admitted, didn't he, to you that he did have items in that bag that would be of concern?
Phone and narcotics.
Okay. But again, you did not search that bag until such a time as you obtained a search warrant for
Yes,
it.
ma'am.
And in that search warrant, you also included not only the totality of what you've already told us, that there were the downloads and all the reasons that you had to believe that child pornography would be found on a device that he owned, you also included in there that he actually admitted that there would be a phone in there.
Yes, ma'am, and
And
that
there'd
was
be-
post-Miranda.
And then did you in fact find child pornography on that phone?
Yes, ma'am.
Approximately how much was found on there?
Over 200 images and videos, if I recall.
And would that be that would be consistent with someone that had downloaded on numerous occasions and then saved the child pornography that they had downloaded?
Yes, if memory serves me correctly, a peer-to-peer program was found on that phone as well.
Okay,
So that matches up to our investigation.
So because of the peer-to-peer program being there, that basically made that device then able to access the internet and download that.
The device access to the internet via probably Wi-Fi, and then the peer-to-peer programming is what allowed that device to then pull what is called torrent files from the BitTorrent and then download onto the phone.
So did that further then basically strengthen your case that Mr. Johnson had been downloading the child pornography that was found on his phone using the internet or other locations?
Yes, ma'am, because it matches up with our investigation. Peer-to-peer program was being used, peer-to-peer program was on the phone, and then images of child sexual abuse material.
Thank you, Investigator Evans. Thank you.
I have just one follow-up question.
You may.
Investigator Evans, this book's all indicated that nobody, that the device we're talking about is a phone. And I had to ask you the question if anybody else had saw Mr. Johnson using a computer to access the internet. Did anybody tell you that they saw him using his phone to access the internet at any of these prior locations?
No, sir.
No? Or
No,
you-
sir.
No? Okay. That's all. Thank you.
Thank you, officer. I think you're excused. Does he need to stay around?
No, Your Honor.
Okay, thank you.
Thank you, sir.
You're released. Mr. Niddle?
Are we ready for argument, Judge? Is that what you're...
I don't know, do you got any other witnesses?
No, that's it.
Okay.
I don't believe it.
So defense rest?
Yeah, we were.
Does the state wish to put on any witnesses? Just make arguments.
Just argument, Your Honor, please.
Mr. Niddle, you may make your argument.
Judge, as I stated in my motion to suppress, I think there's three basic issues here. First of all, the detention of Mr. Johnson. And according to the officer, that detention was based on suspicion, and that suspicion is based on 3 prior search warrants, and people at the location of those search warrants indicating that Mr. Johnson had been present at those locations. That's the only, now, I guess those are facts, but nobody at those locations said they saw Mr. Johnson accessing the computer. Nobody said they saw him using his phone to access the computer. Nobody saw him downloading anything. It's nothing more than the fact that he was in the same area where child porn was being downloaded. I don't think the case law that I was providing to the court as far as the detention is Ricky Smith versus the state of Florida, and more importantly, Ted Popple versus the state of Florida. The Popple case is a Supreme Court case. In Ricky Smith, that's a District Court of Appeal out of the 2nd District in 1992. This was a drug case. It states, in order to justify a temporary detention of a person, there must be a founded suspicion in the mind of the officer that the person is committing, or is about to commit a crime. Wilson v. State. A founded suspicion is one that has some factual foundation in the circumstances observed by the officer, when those circumstances are interpreted in light of the officer's knowledge. Popple is a Supreme Court of Florida case. It says, in order not to violate a citizen's Fourth Amendment rights, an investigatory stop requires a well-founded, articulable suspicion of criminal activity. Mere suspicion is not enough to support a stop. And I would submit to the court that the detention of Mr. Johnson in this case was based on nothing more than mere suspicion, because there was no factual evidence. Nobody told Officer Evans that they had seen Mr. Johnson downloading anything. They had absolutely no evidence that Mr. Johnson did anything other than be present at these locations. And that's, in my opinion, that is mere suspicion. And I don't think it's based on any factual basis. And I believe that the detention of Mr. Johnson was clearly not sustainable. Once he's detained, anything he agrees to take him to his camp, he agrees to let him look at his back. That's coerced consent. He's detained illegally. There is no legal basis for detaining Mr. Johnson. Anything he consents to after that point is coerced consent and illegal. Seizure of the bag, I don't realize there's a case that's pretty much on point called State versus Darter. It's a Florida case out of the 4th District. Basically, in Darter, the state had information. They had an IP address similar to this. The IP address they had that were child porn being downloaded, the IP address they had came back to Jeffrey Darter. The downloads were on a Kik account. The IP address was Darter's. The email associated with the Kik account listed the initials JD as the subscriber. And then after they confronted Mr. Darter, he went off, and they were searching his office computer. They confronted him at his office, and They were able to observe him in the break room, swiping through his phone, and what they believed to be that he was deleting something. The difference here is the IP address we're talking about is not Mr. Johnson's IP address. And they had no indication that Mr. Johnson was trying to delete anything or to do anything in order to seize this bag. In Babcock versus the United States, this is a United States Supreme Court case. And one of the head notes that says, police may briefly detain property, Terry stop style, on the strength of reasonable suspicion alone. Reasonable suspicion as required for a Terry stop requires specific, articulable, and objective facts reasonably to suspect that a crime is being or soon will be committed, but is less demanding than probable cause. And then it goes on to say, a police officer's 2-day detention of defendant's cellular telephone on suspicion of child pornography was not permissible investigatory detention of the property, but instead was a full-blown seizure that required probable cause. Although the government had a compelling interest in preventing creation and distribution of child porn, intrusion into the defendant's possessory interest in his private property over the weekend was serious due to breadth and depth of personal information, cell phone stored. And it goes on to state, but basically it requires probable cause to seize his bag. And I don't think they had a reasonable suspicion, let alone probable cause. I don't think they had a reasonable suspicion to detain Mr. Johnson, and I don't believe they had probable cause to seize his bag. Thank you.
You said there were three things, the detention and the seizing of the bag. What's the third thing?
Oh, I'm sorry. The search warrant for the bag itself falsely states that Mr. Johnson was observed, or Mr. Johnson was, let me read the search warrant, I don't want to misstate it.
That didn't come into evidence, anything about the search warrant, not
I asked
sanctioned.
you about the search warrant for the bag.
I think you asked about the search, you didn't ask this question.
Sir?
Go ahead, I'm not clear what you're arguing.
I'm saying that the affidavit for the search warrant for the bag says Garner continued that Johnson was living at the residence and had access to the internet during the time frame of the downloads. And the downloads, which were the dates that we talked about, June the 19th to June the 29th, and January 18th to 19th. And Mr. Garner did not. He said that he believes Mr. Johnson was at his place on January 25th, which was what Officer Evans asked him about. Was he here on January 25th? I believe he was. So I'm not sure. I believe he was his response. Didn't say anything about the June the 19th to the 29th or January 18th to 19th, which was the time frame. And in his affidavit, he claims that Garner indicated that Mr. Johnson was living at the residence and had access to the internet during the time frame of the downloads. And I assert that that's a false statement. And I would provide the court with copies of my case law, if I may approach.
You may.
This is Smith and Popple. The Supreme Court. Sorry, I printed on the back of it. And this is Gardner's state.
And what fact, what, I want you to actually quote from the search warrant that you say is false. The search warrant, I want you to quote from the search warrant and tell me exactly what statement you say is false.
On page 4 of the affidavit,
Okay?
where it says probable cause on page 4,
I'm with you.
the third paragraph down. During
Okay.
the execution of the search warrant, your affidavit interviewed Mark Garner, primary residence, 715 Glen Place. Post Miranda, Garner admitted he paid for the internet, but denied downloading or possessing child sexual abuse material. Garner confirmed that Johnson was living at the residence and had access to the internet during the time frame of the downloads. And the time frame of the downloads was June the 19th to June the 29th, and January 18th and 19th. Mr. Garner did not confirm he was there during that time period. He said that he believed he was there on January 25th, which was the question that Officer Evans asked him. He did not say he was there during the time frame of the download.
Okay? Ms. Boston?
Your Honor, interestingly enough, the state has cited the same cases in our response, our initial response, as the defense has cited, because we actually believe that they stand for exactly the facts and circumstances of this case. Your Honor, the case law is very clear, and it's actually discussed in the Darter case, the 3 levels of stopping, that an officer may make a citizen contact at any time. They may approach an individual and choose to speak with them. That individual can then choose to walk away. In this case, Investigator Evans initially approached the defendant, Mr. Johnson, asked to speak to him. As soon as Mr. Johnson basically became less than cooperative and Mr. Evans began to, or Investigator Evans chose to start questioning about the circumstances and continue his investigation, because as he said, he had already developed Mr. Johnson as a person of interest. At that point, it was about 58 seconds into the encounter, he did read him his Miranda rights. And then at that point indicated that he was being detained. That is then the second level that is discussed in Darter, where if an officer wishes to detain an individual, they must have a reasonable suspicion that they've committed a crime. Investigator Evans did articulate for us why he believed that Mr. Johnson was a person of interest and why he had reasonable suspicion to read him his Miranda rights and then detain him. The fact that there was, based on the totality of the circumstances, and the test is, Your Honor, what is known to the officer at the time. Not necessarily what they may learn later, what they know at the time. At the time, Investigator Evans knew that there had been numerous downloads using a peer-to-peer program with various IP addresses that came back to specific residences where child sexual abuse material was being downloaded during specific time frames. When they executed those search warrants, there were at least the 3 of them that he spoke about. There was no child sexual abuse material found there. And all of the individuals that were living there at the time indicated that at the time of the downloads, Mr. Johnson had been living there. So that led Investigator Evans to believe that an individual that was residing there at that time would have been downloading child pornography and had taken the devices with them, which would be consistent with an individual that is living a transient lifestyle, or really anyone that's vacating a residence. When they leave, they take their electronics, that which is important to them, with them. You also had Investigator Evans articulate that one would need an electronic device to access the internet and then have the peer-to-peer program on that device to then be able to download the child pornography, and that would be where it would be normally stored by individuals that download and then collect child pornography. He knew that to be also the case that in each and every one of those cases that had happened. Additionally, Your Honor, there was the fact that he was aware of the fact that there had been public downloads from Wi-Fi, public Wi-Fi, within as close as 500 or 600 feet of a place where the defendant was staying, and within a 5-mile radius, various public Wi-Fis, where again there were internet was being accessed for the peer-to-peer program, and child pornography was being downloaded. All of those places where the defendant had access to. So he had numerous facts that pointed to the fact that the defendant was involved with downloading child pornography at those various locations. That's what the reasonable suspicion that he had at the time when he detained him. So we do believe that based on the case law cited in Popple and then in Darter, that is a legal it was a legal detention, and that was appropriate at the time. Then, Your Honor, he chose not to seize the bag at that time and followed him to the camp. He allowed him to freely walk there to the camp. Yes, he was still detained because he had already read him his Miranda rights. He's involved in an investigation, and it's reasonable at that time. He already had the reasonable suspicion to detain him. Once they got to the camp, the defendant at that point actually tried to, as he testified, distance himself from the bag that Investigator Evans was able to articulate he believed contained electronic devices. Based on the lifestyle of the defendant, it was reasonable to believe that he would take his electronics with him, where he believed the child pornography would be stored. He also believed electronics would be present based on the fact that he had the headphone to a new, it was the headphone that was seen in the video actually, to a new phone that would have hooked up to the phone that the defendant actually later admitted to having in there. Also at the time of seizure, he indicated that the defendant had already told him, "That is my bag. Yeah, you can look in it." That was part of the discussion as they were walking over. So he'd already admitted ownership of the bag, and now he's trying to get rid of the bag. So as Investigator Evans told us, based on the totality of everything he knew, he did have probable cause to believe that there was the instrumentality and evidence of a crime contained in that which he chose to seize at that time, which was the bag, which he believed contained the phone, which he believed contained the child pornography. It was an exigent circumstance, which is under Darter, if you have probable cause, which we believe he had, then you may seize something if you can establish exigent circumstances. Darter said that. In this case, we do believe that Investigator Evans articulated that there were exigent circumstances. The defendant is trying to distance himself from the item that he already indicated he owned. And that as even, as I quoted in my response, and as the Badcock and then Darter courts have quoted, when you're dealing with electronic devices and electronic media and digital evidence, it would actually be basically foolish to allow a defendant to have access to that once you believe that that is evidence of a crime. I'm paraphrasing that, but that basically courts have said it would be foolish if you believe there's evidence of a crime to give the defendant or allow them access to the digital evidence. In this case, we believe that Investigator Evans was able to articulate that he felt that he believed there was evidence of a crime there. He did have probable cause to believe it was there, and that he felt that if the defendant distanced himself from that, there was a good likelihood that that evidence could either be destroyed, tampered with, or leave the area, and he wouldn't be able to further investigate. Additionally, Your Honor, he took the additional step of not actually searching it at that time. He did obtain a separate search warrant for that. As part of that search warrant, he was also able to articulate in the probable cause not only the totality of the circumstances that led him to believe there would be something in that bag that was evidence of a crime, but also the fact that the defendant had admitted to it. That was also contained in the probable cause. In the search warrant that you have in front of you.
Admitted to what?
I believe he admitted to our narcotics and a phone in the bag, is what he said in the probable cause. And that he also made statements that there was incriminating evidence on the cellular phone. So that was also part of the probable cause statement in the search warrant that the court has. Now, Investigator Evans did testify that As far as in speaking with Mr. Gardner, that he was able to confirm from Mr. Gardner, not necessarily the specific dates, but the fact that the defendant did reside at that address at one point and also continued to have access to the internet and that address of 715 Glen. But again, the fact that nothing was found there at 715 Glen after the defendant had vacated the residence, even though he still had access, it's reasonable to believe he's taken that evidence with him when he leaves. But the fact that nothing was found there at 715 Glen actually supports the totality of the circumstances of what we've been seeing all along. Defendant lives there, child porn's being downloaded. When he leaves, he takes it with him. So we do not believe that the detention was illegal. We do not believe that the seizure of the bag was illegal. And we do not believe that there is a concern with the search warrant because actually, based on the totality of the circumstances, there is probable cause to believe that there would be evidence of a crime found therein and that it belonged to the defendant. We ask that the court deny the motion to suppress and also rely on our original response.
Okay. Thank you very much for both the state and the defense's efforts to educate the court and to try and tie it into the circumstances that we have before us. The court is going to deny the motion to suppress the evidence. The court specifically finds that there were, and based on the defense's arguments, that there were 3 issues. And the court finds that the detention was proper, that there was reasonable suspicion based on the conversations that were had and the totality of the circumstances. The second issue was whether or not the seizure of the bag and the searching of the bag was proper. And again, the court does find that those are reasonable, the exigent circumstances, the fact that the defendant said it was his bag and then tried to give it to somebody else. The defendant said he could search the bag and then denied him the ability to search it. And that there was ultimately probable cause to search. And that is also shown by the fact that another judge issued a warrant that stated there was probable cause to search the bag. So you got another judge, basically looking at all these circumstances and stating that that there was probable cause to ultimately search the bag. And finally, the last argument was that defense is arguing that the probable cause affidavit was just false. I didn't hear the evidence exactly the way and with the specificity. There was some vagueness as to when the defendant was at the house and what exactly he did and who saw what. But there was sufficient evidence, again, looking at the totality of the circumstances, and that the statement that was contained in the probable cause statement was, the court doesn't find that it was false. So with that, the court denies the motion to suppress.
Thank you.
Okay. Thank you all very much. And again, I appreciate the efforts of the attorneys to articulate and to help educate the court. Okay. Thank you very much. I'm sorry?